McMichael called 911 to say that he believed he saw someone on that property at 220 Satilla Shores Drive, the home of Larry English. And police are going through this home. They're trying to find someone who's inside. Officer Rash is the one who helped present this to the jury today. The prosecution was able to draw from him that he did not see Arbery at any point in those prior occasions, that surveillance video, taking anything, did not think he was a burglary suspect, but was adamantly trying to help this homeowner find him, tell him to leave, trespass him, give him that notice of a trespass so that he would not come back. We also see the communication between the McMichaels and police about the subject of this person in Satilla Shores, and the defense really harped on this, even asking police why they drew their weapons when they were going through the house looking for the suspect, if they did not believe that it was possible that he could be armed and could cause them some kind of harm.
All right. Julia, Janae, thank you. I know they're still in court. You're going to be reporting to us and telling us all of the latest. Thank you so much for all of your great information there from Brunswick, Georgia. I want to welcome now criminal defense attorney Mark O'Mara and former homicide prosecutor Melba Pearson. And I'd like to ask both of you your thoughts about the racial tensions in this case, inside and outside of the courtroom. If I could start with you, Melba, in discussing some of what's going inside of the courtroom.
Yes, absolutely. So what we are seeing is incredibly troubling from the standpoint that trials, unless there's a direct order by the judge, by nature are public. So any member of the public can come in at any point in time unless they're being disruptive. And then at that point, they're removed from the courtroom if that's what the situation warrants. But these are public and open proceedings. So the fact that he not only pointed out a pastor, but pointed out by race, a black pastor, saying that he should no longer be in the courtroom, just further inflames the issues that have been of concern to so many people as to whether or not, the race really is playing a huge role in this. And the defense keeps making it squarely about race by pointing out a black pastor, by deliberately removing black jurors from the pool, right? So because there was a huge concern around the fact that this is a predominantly white jury. We have a victim that is African-American, black, and so now you don't necessarily have a jury of their peers, right? Constitutionally, of course, the defendant has to have a jury of their peers. But when you have a situation that is so heavily steeped in questions around race, it would have made more sense to have, more people, a more diverse jury pool to be able to come to a final decision. So the defense keeps putting race front and center, even though they're trying to make these comments and saying that, oh no, race is not an issue here. They keep making it more of an issue than it even needs to be.
All right, Mark, let me bring you into the conversation. What are your thoughts around what's been happening in the courtroom and racial tensions, if any?
Well, this is an undeniably racially infused case. You can't read an article about this, watch a news coverage about this, and not realize that what this is a young black male tracked down, seemingly for doing virtually nothing wrong, but presumed to have been doing something wrong, and then shot and killed. And the idea that anyone would suggest that the racial tensions inside and outside aren't palatable and just there is sort of absurd. And then lay on top of that the ignorance of a criminal defense attorney who's been out of law school more than a week or two to say something about the racial tensions by focusing on Reverend Sharpton being in the courtroom, to me, just crystallizes not just the ignorance of it, but crystallizes the racial tensions that are going on, and maybe the lack of awareness or understanding that not only Mr. Goff has, but maybe, some others in the community about how to treat racial issues properly.
And the fact that, yes, it is a public courtroom. Individuals are allowed to go from the public to watch the trial. I'm going to leave you all right here to stay with us, but we're going to return to court because they are in session, and we're going to see what's going on in the courtroom.
In fact, as it turned out, there was another important video in this case, or set of videos, were there not?
If you're referring to the videos at his house, yes, sir.
The night owl videos.
That's correct.
Somehow, in their exhaustive investigation, the Glenn County Police Department, for whatever reason, did not obtain those videos.
That's correct.
And you were unaware of the existence of those videos until Mr. Roddy Bryant brought them to your attention.
Yes, sir.
Now, directing your attention to May 11th, did you tell Roddy Bryant that the past week had probably been one of the worst of his life?
Yes, sir.
And he agreed with you?
That's correct.
I believe you've already testified that the McMichael defendants had been arrested.
That's correct.
The GBI director, Vic Reynolds, had given a press conference, and your agency...
I'm going to object to anything from the press conference, Judge. That's hearsay.
I have no intention of going into the contents of the press conference. But your boss, former Cobb County DA Vic Reynolds, at that time GBI director, had actually given a press conference in this case.
Yes, sir. That's correct.
You were physically present when he did so.
Yes, sir, I was.
Okay. And whether you were present, you were aware there was a press release.
I'm aware there were press releases going on.
And when you were speaking with Mr. Bryan, what you described as media and quote-unquote other entities were blowing the situation up even more.
Objection to relevance, Your Honor, in terms of the relevance of what Agent Seacrest thought about the media.
Based on the conversations we had yesterday outside the presence of the jury, I thought the import of this line of questioning was clear.
If you're asking the court that, no.
Okay.
So...
Well, I'm at the court's direction, but the circumstances surrounding under which statements are made is relevant to their admissibility.
So ask your question again.
Did you describe when you spoke with Mr. Bryan the media and quote-unquote other entities quote-unquote blowing it up even more? Directing your attention to page 12 of the transcript.
And Judge, I'll renew my objection.
Yeah, let's see where this is going. Go ahead.
Page 12.
Remember to look at page 12 of the transcript.
Yes, sir. On which transcript?
The 511.
Okay.
And at any point in time, if you're not sure what I'm asking you about, don't hesitate to let me know.
Thank you. Yes, that's correct.
And you noted that the media was already parked out front of Mr. Bryan's residence when you first attempted to make contact with him.
Your Honor, again, relevance.
Yeah, but go ahead.
Yes, the media was there.
And that media craze only got worse in the days to follow.
The media was present.
Okay. And again on 5/13, 2 days later, when you speak with Mr. Bryan again, you acknowledge that the past 2 days have been, quote, difficult for Mr. Bryan, unquote.
Yes, sir.
Because there's even more media now.
Is that a quote?
I don't think that's a quote. But there were more media.
I'm sorry, you're asking me a question?
I'll move on. You discussed with Mr. Bryan the march through his neighborhood. Page 139 on your 513 transcript.
I do recall that.
You sympathize with unusual activity in the neighborhood.
Yes, sir.
You've previously agreed that in the context of this interview in May of 2020, that this was a neighborhood on edge.
That's correct.
And by this time, Mr. Bryan fears for his own personal safety and that of his
Objection
family.
to speculation.
Directing your attention to page 142 of what I believe is the JVD transcript.
The which transcript?
The transcript on his prior testimony. in this trial.
Why don't you give her a date? Let's zero everybody in.
Fair enough. Volume 1 of the proceedings of May 13, 2021. Do you have that transcript, sir?
Not here on the stand with me, no, sir.
I think I have it. This is an excerpt of your testimony.
Thank you. What page?
Stretching your page to page 142.
Oh, I'm sorry, which statement, which part of it?
Page 142, lines 3 through 7.
Yes, sir.
Do you recall being asked whether Mr. Bryan and his fiancée related multiple occasions, incidents that gave them concern for their personal safety?
Yes, sir.
Do you recall Mr. Bryan's fiancée, Amy, giving you a threatening letter that she pulled out of her mailbox?
Hearsay, Judge. Anything in that letter is hearsay. And relevance as to Amy Elrod.
I'll
It's not a
rephrase.
party in this case.
I'll rephrase. In the presence of Roddy Bryan, did his fiancée, Amy Elrod, give you a letter that she pulled out of her mailbox?
Same objection, Your Honor. I don't know if there's any
It's certainly
evidence.
not hearsay. We have not even the contents of the
Yeah,
letter.
and what's the relevance of it? Is there any evidence that Mr. Bryan read the letter? I mean, what?
I'll rephrase. Did Mr. Bryan ask you to do something to help protect him?
I don't recall that directly. I know there were general concerns about his personal safety,
Yes, sir.
and there were multiple conversations about it.
Is it fair to say that Mr. Bryan was very much concerned about speaking with you at this time?
Objection to speculation, Your Honor.
I'll rephrase. Would you describe Mr. Bryan as scared?
Not of me.
Oh, I'm sorry. I didn't mean scared of you, but scared generally.
Because of the situation in the neighborhood, yes, sir.
And you still need his help.
I would like his assistance, yes.
And the last thing you want Mr. Bryan to do is freak out.
I don't want anybody to freak out.
You certainly don't want him to shut down because you want his help.
I'd like to get statements from anybody involved in an investigation.
Yeah. Sir, I'm going to direct your attention to the bottom half of page, I'm sorry, the bottom 2/3 of page 3 of the transcript, the 511 transcript. With the chairman?
Yes.
Sir, I'm showing you an enlargement of page 3 of that transcript, that portion.
Is there an exhibit number?
No, this is not marked for an exhibit. The full transcript is already an exhibit. Correct. Do you recall that conversation?
Yes, sir, I do.
Okay. Can you read that conversation to me?
From the ones you handed to me?
Yeah, or you can read the smaller print on the document, either way.
I stated, I do appreciate you. You said you would call me back, and you did. And you said you wanted to talk, and you are. I appreciate that. I want to tell you thank you. Like I told Mr. Goff said, Kevin, and I replied, Kevin, yeah, it takes me a second sometimes. You know, at this point, you're a witness, you know. That's kind of what we've developed, or I shouldn't say developed, but determined by listening to all the evidence and the statements and watching videos. There are things that that we have questions on, and that we'd like to I guess, be a little more specific than what we've been able to see, you know. But I do appreciate you coming in.
And that is what you said?
Yes, sir, that is what I said at that point in time.
Help? It was important for you to let Mr. Bryan know that he was a witness in this matter.
It was important for him to know that I appreciated him calling me back like he said he would after my initial contact with him. It was important that he know what his role was at this point in time. And I wanted him to understand that I was looking at this objectively from a fresh set of eyes and not going strictly off of what the Glenn County Police Department had relayed.
When you told him that you had reviewed the previous statements to the Glenn County Police Department and the other evidence in the case, you weren't lying to him, were you?
I was not.
You did, actually. You had all that information available to you.
Yes, sir.
And you know that the Glenn County Police Department had referred to him as a witness.
I don't recall that specifically, but if it's in there, it's in there.
Okay. Well, you reviewed their case file.
I did, in pieces, I would say.
And when you became involved in this case, the Glenn County Police Department listed him as a witness.
Asked and answered.
I don't think so, but I'll defer to the court.
Yeah, go ahead. Go ahead.
The Glenn County Police Department had identified him as a witness in this matter.
I don't recall.
Okay, fair enough. But you told him that he was a witness.
I told him at that point in time.
Which would be consistent, as far as you know, with everything he had been led to believe.
Objection to speculation as far as what Mr. Bryan was led to believe.
Hold on. You had Mr. Bryan execute a consent form, I believe. May I put a screenshot? Yes. I'm showing you what's been marked State's Exhibit 197. Thank you. I believe you read that to the jury earlier.
Yes, sir, I did.
Where in there does it tell Mr. Bryan what he's under investigation for?
It doesn't.
Okay. Thank you, sir.
I would add, though, that he knew what the investigation was about, being as the whole case was around Ahmad Arbery and his death.
Well, we'll come back to that. Maybe I slept through it earlier, but where was the Miranda form that you used on this occasion?
He was not under arrest. Miranda is only required when somebody's being questioned while they're in custody. At no time was Mr. Bryan in custody during these questioning. As a matter of fact, he was advised from the beginning that he was free to leave and that he was free to stop talking at any time, to which Mr. Goff was present during those conversations.
Well, let's be clear. You were under no legal obligation to give Mr. Bryan Miranda rights, but you could have.
There's no reason to.
But you could have.
I could do a lot of things, but there's no reason to read him Miranda if he is not in custody, or there's no chance of him being put into custody at that time.
You've never Mirandized somebody who wasn't in custody?
I do a lot of different things depending on an investigation.
And we are continuing to watch the defendant, Brian's attorney, question this GBI special agent about what he told him when he interviewed him. We'll be right back on the other side with more continuing coverage in Brunswick, Georgia.
Tonight on Closing Arguments, everything you may have missed from the killing of Ahmad Arbery murder trial. Court TV will live from Brunswick, Georgia, bringing you every update.
Closing Arguments with Vinny Politan, tonight at 8/7 Central, only on Court TV.
Ben was a leader in the reptile community.
Right by his side is little.
He was in love with her.
That is about to change. Ben is found dead.
The suspect, his wife.
Mystery on a snake farm premieres November 21st, only on Court TV. Oxygen True Crime has TV's biggest rush.
Fire on the second floor.
Every chair is a hot seat.
Shots fired.
Every call an emergency.
I'm getting a lap dance.
Well, almost every call.
They're not giving me my money back.
Experience the heartbreaking,
She may be suicidal.
heart-stopping,
Umbilical cords around her head.
heart-warming moments.
Is the baby crying? She's breathing. Oh, thank you so much.
Only Oxygen True Crime has the new series 911 Crisis Center.
Hi, my name is Sam Davis, and I'm going to tell you about exciting Medicare Advantage plans that can provide broad coverage and still may save you money on monthly premiums and prescription drugs. With Original Medicare, you're covered for hospital stays and doctor office visits. But you have to meet a deductible for each, and then you're still responsible for 20% of the cost. Next, let's look at a Medicare supplement plan. As you can see, they cover the same things as Original Medicare, and they also cover your Medicare deductibles and coinsurance. But they often have higher monthly premiums and no prescription drug coverage. Now, let's take a look at Humana's Medicare Advantage plans. With a Humana Medicare Advantage plan, hospital stays, doctor office visits, and your Original Medicare deductibles are covered. And of course, most Humana Medicare Advantage plans include prescription drug coverage. In fact, in 2020, Humana Medicare Advantage prescription drug plan members saved an estimated $8,400 on average on their prescription costs. Most Humana Medicare Advantage plans include a Silver Sneakers fitness program at no extra cost. Dental, vision, and hearing coverage is included with most Humana Medicare Advantage plans. And you get telehealth coverage with a $0 copay. You get all this for as low as a $0 monthly plan premium in many areas. And your doctor and hospital may already be a part of Humana's large network. If you want the facts, call right now for the free decision guide from Humana. There is no obligation, so call the number on your screen right now to see if your doctor is in our network, to find out if you could save on your prescriptions, and to get our free decision guide. Humana, a more human way to healthcare.
This is Drive Time, where you have a 99% chance of getting approved for a car, even if you don't have great credit. You may even qualify for $0 down.
Awesome, because my credit is...
Great. That's why we built the Smart Approval Machine, or SAM.
Hello. Is this a real machine you guys use for approvals?
Oh, no. These buttons don't even work. You get approved on your phone.
SAM is for fun, ha ha.
We use a ton of different factors to get you approved, not just your credit score.
I got approved.
I told you, 99% of people do. Go to drivetime.com, get approved, and see if you qualify for $0 down. Drive Time. Genius.
Welcome back to Court TV Live. We want to take you straight back into court in Brunswick, Georgia, where there's continuing cross-examination of the 14th witness, the GBI agent, Seacrest.
Just saying that.
That wasn't me.
Well, you directed him to it.
No, I directed him to the breaking the conversation.
May we approach, Your Honor?
Still with me, Mark O'Meara, criminal defense attorney. I want to bring you in. I may have to cut us off because we may want to go back into court. But Mark, tell me what you think of this cross-examination. I think the point of it is really to portray that his client, one of the defendants, was being interviewed as a witness in this case.
Well, that's great. And there's nothing wrong with being identified as a witness, but that doesn't mean that you can't be turned into a defendant. And though it may be making some inroads with the jury, because it might be confusing them a little bit, as though if he was a witness, then you shouldn't use his information against him. Those of us who actually know the law know that he wasn't in custody. Miranda was absolutely not necessary, nor even appropriate. They interview witnesses all the time, and then when he turns into a potential defendant or then a defendant, if the statement was voluntary and not in custody, it comes in. And this argument of fear, or you told him you're a witness, quite honestly, I think is a smokescreen to try and gain some benefit with the jury that somehow this was inappropriate when it just wasn't.
And Mark, I keep wondering if he's going to get to a point to try to get out that it should have been a case in which he was Mirandized. I don't think so, but let's go back to court. I believe that questioning has resumed.
Mr. Goff says, right, you stay, we're stepping out.
And Mr. Bryan says,
okay.
And then you say,
no, you're good, you're good.
And then I say,
we're stepping out, okay.
And then you and I stepped out.
That's correct.
And when we came back in, what did you tell Mr. Bryan?
I know not everybody talks to the police every day, and I know this is a very stressful situation, but you know, we're going to be okay here.
And Mr. Bryan says,
okay.
Okay. And then you say,
all right, we're going to be okay. I mean, nothing has changed. When we're done here, you're going home, okay?
And Mr. Bryan said,
okay.
Because he's just a witness.
I believe that our question or our conversation outside was to Roddy's nervousness about talking to police and his trouble recalling events. And I believe you were speaking for your client as to his ability to recall events.
Because it's an issue. It's an issue when you're dealing with him that day.
I don't remember it being as much of an issue for him as it was for you.
Really? Okay. All right. Now, on May 11th, Mr. Bryan gave you an hour-plus interview, did he not?
Yes, sir, that's correct.
Hour and 15?
Something like that.
No, on May 13th, he comes back and gives you a 2-hour interview?
That's correct.
And he speaks with you in his home, does he not?
The May 13th interview for 2 hours?
In addition to the 2-hour interview at the DNR headquarters, he invites you into his home and meets with you in his home.
That's correct. After discussions with you, it was advised that we could go to his home. I believe that was to download the Night Owl camera system. It was not an interview. It was a matter of gathering evidence.
And you spoke with him out in the front yard.
Not about the facts of the case as much as it was the logistics of the video and everything else.
And you're speaking with him down when you're getting his fingerprints.
After you and I had already had a conversation where I promised I wouldn't ask any questions about the case during that time because you weren't present.
Because you had built a relationship of trust with Mr. Bryan.
Which I try to do with all of my witnesses and all of my people that I discuss with cases, whether it be subjects, whether it be witnesses. To the point where I've gotten text messages thanking me from people that I've arrested because I've treated them fairly.
And in case it wasn't clear earlier, in all these interviews that transpire over several hours, you're discussing a lot of different subjects.
Yes.
Path of travel is only one of those.
I'm sorry, say it again.
Path of travel. The video, the now famous video, that's one of the subjects of those conversations.
You mean the recorded interview conversations?
Yeah.
Yes, sir.
I mean, you're not drilling Mr. Bryan for 2 hours at a time, an hour and a half at a time about this one subject.
No, these interviews are very conversational in nature about the events that happened on that day, before and after.
And it was through no fault of yours, but Mr. Bryan nevertheless had trouble articulating what was going on that day?
No, sir.
He didn't?
You said it was no fault.
Well, it was no fault of yours. You were trying to work with him.
I was working with him. Yes, sir.
Okay. Now, on May 11th and May 13th, did Mr. Bryan appear at any time to be mentally unstable?
No, sir.
Did he appear to be under the influence of alcohol, drugs, or other intoxicants?
No, sir.
Was Mr. Bryan loud or boisterous?
No, sir.
Did he come across to you as gleeful or bragging or boastful?
No, sir.
Did he strike you as someone seeking attention, seeking the spotlight?
No, sir.
Did Mr. Bryan drop F-bombs or otherwise use profanity when you were talking to him?
No, sir.
Was Mr. Bryan in any way disrespectful to you?
He was not.
Okay. Now, there are times in the transcript where you and Mr. Bryan are discussing the deceased in this case. Mr. Arbery, by his first name.
That's correct.
Okay. In doing so, you didn't mean any disrespect.
I don't see that as disrespectful.
Okay. And certainly when Mr. Arbery said his name, you didn't take that as a disrespect towards Mr. Arbery.
When Mr. Arbery said his name?
When Mr. Bryan said Mr. Arbery's first name, you didn't take that as a sign of disrespect.
No, sir.
Did you ask Mr. Bryan how far he got in school on either May 11th or May 13th?
Not to my recollection, but I think he did tell me that he graduated from Brunswick, if I remember correctly.
Did you ask him whether he had any learning disabilities?
No, sir.
Did you ask him whether he could read and write the English language?
I don't recall specifically if I asked that one.
You don't recall him replying most of it?
I do recall that, yes, sir.
Now, Mr. Bryan never denied following Mr. Arbery, did he?
That's correct.
And while he might not have used the word, Mr. Bryan never denied angling his vehicle ahead of Mr. Arbery.
He never denied angling his vehicle in that direction. His choice of words changed drastically from the point of the Glenn County interview to the point of his interview with me.
I'm sorry, did I ask you whether he changed his wording, or did I ask you whether he denied angling his vehicle in front of Mr. Arbery?
Objection, Your Honor. The witness is allowed to explain his answer, which I believe is what he just did.
What a witness does is answer yes or no, and then they can explain.
Would you state your question again? Go ahead.
Roddy Bryan never denied during his interview with you that he angled his vehicle ahead of Mr. Arbery.
That's correct. He never denied. He just changed the descriptive words that he used in his involvement in the incident that day.
Didn't you just tell the jury when the district attorney was playing this reenactment? Didn't you just tell this jury, as you pull the truck in where the driveway is in the ditch, didn't you just show them on the video him angling and say that he did that? You just didn't use the word.
Yes, sir. He said that he did that during the reenactment video with me, but the wording was different than his explanation when he was interviewed by the Glenn County Police Department.
But based on your video, whether he used the same words or not, he conveyed the same meaning.
He conveyed the same meaning with different intent.
You know what's in Mr. Bryan's mind?
I don't know what's in his mind, but the use of the English language and the words can give some insight into a person's intent.
Are you trying to speculate as to what was in Mr. Bryan's mind?
I'm not speculating in what is in his mind. I guess I would be explaining what the meaning that I took to those words and what I would say as a general meaning to those words.
Roddy Bryan never denied cutting in ahead of Mr. Arbery, did he?
At which point?
At any point. In your conversation with him, did he ever deny cutting in ahead of Mr. Arbery?
No, he was factually correct in his movements that day during his interview with me.
Okay. Now, beyond that, what you're really doing in this video, and this narrative you've just given the jury is you're largely speculating, aren't you?
About
what happened?
I'm giving insight on what I was told that had happened on the day of the incident.
Okay. Was that Mr. Bryan's testimony, the words you were using when the video was playing, or was that your spin on it?
That would be me paraphrasing what Mr. Bryan told me during that reenactment video.
Mr. Bryan let you know that he didn't think he could do this.
Do the reenactment video?
Mr. Bryan let you know many times that he was struggling to remember events 2.5 months later.
Which is not uncommon for anybody that has to recall events afterwards. But it doesn't stop me from being able to ask the questions. That's my job as an investigator.
Because you needed this reenactment video.
Actually, you offered the video prior to the interview. You referenced that Mr. Bryan had a hard time remembering the path of travel in a narrative format, and that he was willing to take that path of travel after the interview.
So, you took that as the green light to put words in Mr. Bryan's mouth?
I never put words in Mr. Bryan's mouth.
We're making sure we're looking at the same thing. Yes. Sir, is it fair to say that what you did on May 13th in that car was a rehearsal before you recorded it?
I'm sorry, repeat that question?
You rehearsed this video with Mr. Bryan before you recorded it?
Yes, there was a discussion as far as Mr. Bryan's ability to recall exactly what happened, so we did refresh the events prior to actually doing the recording.
So it was practiced. You did a practice run before you turned the video on.
It was a run to refresh his memory because he was having a hard time with the path of travel.
May I show you the investigative summary you prepared?
Yes, sir. Thank you.
Your investigative summary indicates that...
Objection to hearsay, Your Honor, from the summary. If he's trying to refresh his recollection, then that's one thing, but not read from the actual document.
Have you refreshed your recollection now?
I don't believe the witness ever said that he couldn't remember anything.
I'll rephrase. In your written summary, you acknowledge the difficulty Mr. Bryan had in determining his path of travel 2.5 months later.
Yes, just like I stated earlier, he needed an opportunity to refresh his memory.
And it was only after you refreshed his memory that the video was turned on.
I did not refresh his memory. It was impossible for me to refresh Mr. Bryan's memory. I was not there on February 23rd. I could only go off the statements that Mr. Bryan provided.
Oh, but it was possible for you to refresh his memory, wasn't it?
Objection to ask and answer, Your Honor.
Congress race. Mr. Bryan has repeatedly said he's having trouble recalling the events of that day. And in all the times you met with him, and all the times he expressed difficulty, did you ever once offer to show him a copy of his own statement?
No, sir.
You had both of his statements from the Glenn County Police Department at that time, right? You had the video and the transcript. I'm sorry, you had the videos. Okay. Did you've indicated you reviewed them. Did you ever once give Mr. Bryan an opportunity to review what he said 2.5 months earlier?
It wouldn't be standard to have somebody review their statement after the fact. The whole point of the GBI coming in to do another investigation of this incident was to try to start the investigative process from the beginning and basically get a fresh start. I wanted Mr. Bryan's statement from his recollection right then, and I could compare it to what he had said earlier and try to determine if there were discrepancies based off memory issues or if there were discrepancies based off of, I'll call it ill intent.
Where in your 5-page written summary do you ever reference Roddy Bryan attempting to run over Mr. Arbery with his truck?
I don't think it's in there.
Would you like to review it?
It's right here. This one?
Yeah.
I don't believe it's in there.
Okay. To be fair, you weren't investigating Roddy Bryan for an aggravated assault on a motor vehicle, were you?
Was investigating Roddy's involvement in the death of Ahmad Arbery.
Well, certainly, if he had told you that he tried to run Mr. Arbery over with his truck, that would have changed the character of your investigation.
Not necessarily.
Okay. You certainly would have included it in your 5-page summary, wouldn't you?
That's correct.
Because other agents for the GBI and your supervisors are looking at these things as they come in, right?
That's correct.
Okay. Now, you previously testified about an incident where Mr. Arbery, from Mr. Bryan's perspective, appears to be getting in the vehicle.
That's correct.
For trial.
Yes, sir.
And in fact, he expressed a fear to you later that he was going to try again.
That sounds familiar. Yes, sir.
Directing your attention to page 54 of what I believe is the May 13th transcript.
You said 54?
Page 54. Directing your attention to the middle, where Mr. Bryan begins with, well, at first. He tells you he's trying to get out of the way. Tenth line down.
Yes, sir.
Now, he's trying to get out of the way. He says, for a split second, he says, oh my God, he's coming back at me. You recall that?
Yes, that's right before he continued following Mr. Arbery towards the intersection of Satilla and Holmes.
Yes. So he's telling you that I'm trying to stay as far back as I can from this dude.
Yes, but he had also turned around he was already going away from Mr. Arbery, and he had turned around to come back and follow him.
And when he turned around, and I got that video, that split second, then he's coming back at me, and I'm like, oh, expletive. Excuse me again. I don't want to use that four-letter word.
I understand. Yes, right.